Hi, and thank you for watching the webinar on trademarks and copyrights for pro bono clients. I am honored to be Rick, as you no doubt are aware, is one of the most brilliant legal minds of our times. It is a joy to get to work with him each day, not to mention he's great eye candy in the office. I can't believe he's still single. If only I were. Perhaps most of all, his generosity of spirit and, what's that?
Humility.
Humility, no bounds.
Thanks, Carly. Carly and I are here today to talk about trademarks and copyrights in the nonprofit world. Carly is trademark paralegal on our team and is well-versed in the area of trademark, and I work with both trademarks and copyrights. So we'll take it away with Carly telling you a little bit about trademarks to start.
Thank you. Okay, so what I would like to begin with is what you want to consider when beginning with trademarks. The first thing that we like to talk about is brand selection. Who are you going to be? What do you want the look of your organization to be like? Names you're choosing, things like that. Then we'll search and clear those sort of things for you, especially, the first thing you probably consider is the name of your organization or any rebranding if you already are established organization. We want to make sure that your name or any trademarks you intend to use are clear to use and there's not someone else that's already has rights to those. Then we'll talk about prosecution, and sometimes that's a confusing term, but what that means in the trademark field is we will file trademarks and try to gain federal registration rights for you. Also, usage requirements and things that you want to consider when you're using your trademark in the marketplace, and the enforcement of your mark to ensure that other people don't infringe on the rights that you've worked so hard to get. Next slide. Okay, what is a trademark? Simply put, it's a word, slogan, design, picture, anything associated with your goodwill, services, or business. How does a trademark function? Well, there's a few ways. First, it can function as a source indicator. It lets the consumer and your clients know where those goods or services are coming from. It also gives them quality assurance. So one of the examples that we like to use is the Ralph Lauren polo logo versus some other lesser quality brands which you may have seen in the marketplace with similar but different logos. This is something that, if you're going out to buy clothing, you know what the Ralph Lauren polo looks like, the man on the horse with the polo mallet versus maybe a knight who might be riding a horse with, his jousting stick. Different but similar, but that little man on the horse will indicate that is a quality Ralph Lauren polo product, and it's what everyone's come to know as good quality material. It also gives an indication of the goodwill and brand awareness, and this is something that you can build your organization on going forward and in the future. So it gives you a stable foundation to then have longevity and increase on that goodwill.
When I think about that in the nonprofit context, I think of organizations that maybe have a good reputation for funding a lot of every dollar that comes to them, 95 cents goes to the actual recipients of the charity. And if you have a mark that's similar to an organization that maybe doesn't enjoy such a strong goodwill or reputation, then you want to either steer clear of adopting a mark that might be similar to that, or you want to be sure to enforce your rights to prohibit that third party from infringing on your goodwill.
Yeah, that's a great example. Next slide. So now we're going to discuss forms of trademarks. There's several ways that trademarks can present themselves in the marketplace. The most used is a word mark, and as you'll see here, it's simply the name in text form of your business or service. Then you have non-traditional marks, such as what we have here, the shape of a Coca-Cola bottle. It could be packaging that you might use that is unique in the marketplace and really sets your brand apart, but it's going to be similar shapes of designs that you might use. We also have slogans, so it can be slogans or taglines like we have here, "I'm loving it." I'm sure most people will know that that is the slogan for McDonald's. Composite marks, which basically take word marks and design marks and then combine them. So that is considered a composite mark where you have text and design. And then, of course, you have, the logo design or stylized marks, which you'll see here. You can register trademarks in specific fonts, specific colors, or simply just a design with no words. One of the examples that comes to mind for just a design mark is the United Way hands that have become so well known in the marketplace.
So Carly's told you a little bit about what trademarks are and what their purpose is. But I'm going to tell you what's not a trademark. As an intellectual property attorney, the term intellectual property is intended to identify a wealth of different types of property, but not real property. That's why intellectual property is distinguished. And there are different forms of intellectual property. Carly's told you about trademarks, which is one very important and big form of intellectual property, which serves to identify the source of the goods or services being sold using that mark. Apart from that are copyrights. Copyrights are used to identify the underlying content. It's the expression of an idea in a tangible medium, and I'm going to talk about that more in just a second. In addition are patents. I think for patents, most often we think about inventions. It could be processes or business methods as well. But patents are really intended to protect inventions and give people exclusive rights for a limited period of time to their invention. Also, there are trade secrets. Trade secrets are confidential information that you're not going to share widely, certainly not with your competitors. The Coca-Cola formula is kind of a iconic example of a trade secret, but it can be anything from a list of clients. So if that's confidential to you, or a list of vendors, if you've worked hard to kind of cobble that together and build those relationships, and you treat that as confidential information, then that might be considered to be a trade secret. And last is a right of publicity, is another form of intellectual property. Carly, we all have a right of publicity in some form. They can't take my picture and put it on a package of Depends undergarments as the spokesperson for incontinence if I didn't sign up to do that. And likewise, you couldn't lift my image off of this video and use it to promote your charity without my permission, because I have a right of publicity in my name, my likeness, and my image. And those things are protected by a separate body of law than trademarks. With respect to copyrights, as I noted, it's the expression of an idea in a tangible medium. So if you just have an idea, you have an idea that you want to start a charity that is going to give underprivileged girls prom dresses. That's a great idea, but it in and of itself is not protectable. There may be other organizations that choose to do that, and likewise, they cannot prohibit you from moving forward with that idea. But if you fix that idea in a tangible medium, you very likely could have a copyright interest in the idea itself. And here we've got a number of examples. Artwork is a classic example. A photograph, I mentioned you can't use my photograph without my permission. So in this picture, I believe it's of Miley Cyrus. Mm-hmm. It's a pretty dated picture from the more recent Miley Cyrus that I've been witness to. But Miley has a right of publicity in her image. You couldn't just slap that on something. But the photographer also has a copyright interest in that photograph. So to use that photograph to promote your goods or services, you would need not only Miley's permission for her right of publicity, but the photographer's permission for his copyright interest. Other examples are music, books, films, software code, sculptures, or more likely for most nonprofits, written materials. Your website, your brochures, your newsletters, any materials that you use for promotional purposes, any artwork that people create in order to promote fundraising activities or something like that. I know my kids' schools often put together some artwork for posters and things like that. You have a copyright interest in that expression that's fixed in a tangible medium. How do you get this copyright? Well, I've got great news for you. The first thing is you don't have to do anything. As soon as you fix it in the tangible medium, copyright interest is secured automatically. However, that may not be the best way to go about protecting your copyrights. Oftentimes you want to register your copyright. It's not required in order to establish a copyright interest in the work, but in many cases it is recommended. What rights are covered by the copyright? If I own a copyright in something, I have the exclusive right to reproduce it, to prepare derivative works, to distribute it, to perform it, or to display it. So to reproduce it is to copy it. You're watching this film right now. If you copy this film and put it up on your website, you have infringed the copyright of the Pro Bono Partnership of Atlanta, because they have exclusive ownership of the rights, and you have also misappropriated my right of publicity in my image. Likewise, to prepare derivative works. A classic example of a derivative work is the sequel to a movie, Godfather 1, Godfather 2, Rocky 88, whatever it is. Those are derivative works. So if somebody wants to take your original copyrighted work and then alter it slightly or build on it, then they may have violated your copyright interest in that work. You also have the exclusive right to distribute it. You might have a publication that you've printed and you send it out by mail to all of your clients, and then if one of those clients decides they want to go out and collect many copies of them without copying them themselves, but then distributes it to an area where you would prefer not to distribute it, then they may have violated your copyrights. And finally, perform and display, I think, are self-explanatory. Earlier I mentioned that it's not necessary to register, but it is recommended. And I think for nonprofits, it is most likely going to be recommended when you've put some effort into putting that material together. If it's an instruction manual that requires some research, if it's your website, then you probably want to go to the trouble to register it to prohibit others from, to put people on notice, that you claim copyright interest in that. The good news is it's cheap. To file an application to register a work for copyright protection is $65 per application, but it's $35 if you do it online, and I think most people do it online. And once you get that registration, your copyright is protected for the life of the author plus 70 years after the author's death. If the copyrighted interest is in the corporation or the nonprofit organization, then it's valid for 95 years after the first date of publication, or 120 years from creation if for whatever reason you chose to wait 25 years after you created the work to actually publish it. So copyright registration demonstrates the date upon which you first begin use of the copyright work, you've published the work, and will demonstrate the longevity of your copyright interest in the property. All further information, if you're interested in registering for copyright, can be found at copyright.gov. That's the website that you also go to file the online application. And of course, I'm sure a Pro Bono Partnership attorney can help direct you on that as well. Why, you ask me, Rick, do you say that you would prefer that I register some of the materials for copyright protection when I get it automatically just by putting it down? I can pocket my $35 and I'm good. Well, there are a few benefits to doing that. Well, there are many actually, but there are three that I've listed here. One is owning a registration is a prerequisite to bringing a lawsuit. So if you do want to pursue action against, if Carly's lifted my valuable image of myself, my photograph, and used it for her own benefits, then I would probably want to register that photograph for copyright protection, and then I could bring a lawsuit. It also allows a copyright owner to recover statutory damages and attorney's fees. A lot of times it might be hard for me to demonstrate what damage I've suffered as a result of Carly's use of my photograph. And under copyright law, there are statutory damages, and I can recover attorney's fees. So it may be cost prohibitive for me to pursue the action, not knowing whether or not I'd get attorney's fees. And that allows you to do so. And then finally and importantly, it shifts the burden of proof to the other party. Carly has lifted my photo again, and I pursue copyright infringement action against her. It is now her burden to prove that I don't, in fact, enjoy a copyright interest in that photograph, as opposed to if I didn't have a registration, then it would be my burden to establish that, in fact, I am the proper copyright owner, and she has infringed that right. I think I mentioned earlier some materials for which nonprofits may claim copyright protection, promotional materials, educational materials, training materials. Importantly, event photos. I know a lot of nonprofits like to take photos at fundraisers and at events at which they're delivering services to their clients and put them on their websites. Be sure that you've gotten a release from the photographer and from the people featured in those photos before you publish them on your website. Again, the photographer owns an interest in the copyright, and the people featured have a right of publicity in the use of their image. And then finally, your website is probably a pretty good example of something in which you may claim copyright protection. Now, Carly's going to tell us more about trademarks.
Okay, we're going to switch it back to trademarks. So in the nature of brand selection, what we think of in deciding about your brand is what we call the distinctiveness spectrum. So what you'll see on the slide is you go from generic to fanciful, and what that does is you have a more narrow protection, or maybe even no protection in the generic form, to a much broader protection in the trademark world of a fanciful trademark. So generic simply means, in the example here, action figures, or as it relates to a nonprofit, maybe if your organization is called Homeless Shelter, it's simply stating what the good or service is. It is generic. There is no protection provided for naming your organization Homeless Shelter if in fact you are a homeless shelter. Something that may provide a little bit of protection but is still pretty narrow is a descriptive trademark. Our example here is World News for a news network, pretty descriptive of the services that they provide, News of the World. If we think about the charitable field, if your organization is called Feed the Sick, it's descriptive of your services, but maybe not exactly generic. So moving forward into the suggestive realm, let's say you have Meals on Wheels, right? So that is suggestive of your services, but not as descriptive as Feed the Sick was. So you have a broader net of protection over a mark like Meals on Wheels because it is not descriptive, but just simply suggestive of the services that you provide. Another example of a pro bono client I think Rick has worked with is Enchanted Closet. You know, somewhat suggestive of what they might do, maybe provide clothing, but not descriptive exactly of the services. Getting even broader rights and able to garner more protection is an arbitrary mark, such as Dove for soap, or another example we were thinking of is March of Dimes. If you didn't know what March of Dimes did, the name itself doesn't really invoke their actual mission. You might think it's a financial organization that likes to organize 5Ks maybe. So
10Ks.
10Ks, exactly, a good one. So those are arbitrary marks where the name doesn't necessarily relate at all to the goods or services that they provide. And then at the very end of the spectrum, we have fanciful. Sometimes made up words, completely different from anything you could think of as to what they do. Here we have Exxon, which isn't a word, is just simply the only thing that Exxon is an oil company. If you tried to register Exxon for soap products, because it is such a fanciful term, even though they don't sell soap, you are likely never going to get a trademark registration for Exxon for any goods or services because they have chosen such a fanciful mark, and it provides the broadest net of protection over their brand. One organization that we found that we thought was fanciful was Axion International. I don't think that word has any meaning in the English language, so we would consider that fanciful and pretty great spectrum of protection for their brand and their mark.
There's a constant struggle, I know, between the trademark lawyer who wants you to have a pretty fanciful mark so that you can have these really strong rights, Exxon and Axion. These are terms that don't have any meaning, but your marketing people probably want you to have a mark that connotes some meaning to your potential consumers or donors or something like that. So you want to try to find a happy balance between something that is unique and original, but also delivers a message to your consumers that you want it to have.
Another thing to consider when selecting your brand or rebranding is the standards and practices implications that it may present. And this is, consumer perception or any other commercial impressions that you can think of. And, here we use an example of an acronym, right, for your organization. If you were the World Teaching Foundation and you ever needed to, the example I think of is creating apps these days. Oftentimes you are forced to shorten your name so that it fits into the tile that will then appear on a phone. Well, if your initials are WTF, in today's world, that doesn't initially invoke World Teaching Foundation. It invokes something else that you may not want people to think is associated with your organization. So those sort of commercial impressions are really something to think about when you're selecting your brand and creating your organization. So some of the factors that we consider in our legal analysis. So especially if we're searching and clearing your mark and we find some things that we think are confusingly similar, one of the risks that we think about is the infringement risk. And the risk of infringement brings lots of pitfalls with it. And these include if you go ahead forward with a mark that is similar to someone who's already in the marketplace, the risk that you have with infringement is injunction. They could maybe stop you from operating your business. Damages, and those, of course, could be monetary damages that they might be awarded. You could be forced to destroy materials. You would then have the expense of rebranding your organization and you losing all the goodwill that you've built upon that name already. And it's just, in general, like a PR nightmare. Especially in the nonprofit world, your goodwill and your impression is really valuable, and these are things that you would want to avoid running into. So again, another reason to create a brand and select a brand that is maybe fanciful or arbitrary as possible, but still gets the commercial impression across that hasn't already been used by someone else. Another thing we consider is its registerability. How likely are we to get a trademark, to secure a trademark registration for this new brand that you are coming up with? If it is similar to other marks out there, it could be a weak mark. If there's so many other organizations out there with similar names, maybe variations of it, it then creates a diluted market and it makes your brand weak and less able to be registered. It gives you less exclusivity, obviously, and it can also run you into issues when you want to partner with people and maybe get some licensing fees. If you have an organization that's similar to another one with the same name, and your licensor wants like exclusive rights, the licensing fees could be lower because there's other organizations in the marketplace that do the same thing that you do. So those are things that we consider when selecting those names. So confusingly similar is a comparison of several things. So the mark itself, right? So it could be a similar looking word, a similar sounding word, or it could be similar in meaning or commercial impression. One of the examples that we often use when we're talking about this is Delta. So while you have Delta faucets and Delta Airlines, and they are exact in sight, exact in sound, but the meaning and the commercial impression behind that could be different. They also have extremely different goods or services. Their target consumers are different. The channels of trade are extremely different. The sophistication of consumer could vary as well. So even if your mark is exactly the same as someone else's, if a majority of these other factors are different, you could still possibly proceed and coexist with another mark that's the same. So you need to consider not just the mark itself, but also these other factors that we've listed here, which I've mentioned, the goods and services, who your target clientele are, how you trade in the business, what channels you use, and also the sophistication of your clients or consumers.
And I think that's when you go back to the distinctiveness spectrum. If you pick a very fanciful mark, then an exact, the mark itself being exactly the same in and of itself can be sufficient. But if you pick a very descriptive mark, then you're going to have to demonstrate almost every one of these elements. The consumers are the same, the goods and services are the same, the channels of trade are the same. Particularly if you look at the sophistication of the consumer, I think then about, is it a business-to-business consumer or is it a business-to-consumer consumer? And certainly for nonprofits that are dependent on donations, the courts are going to be very sympathetic to nonprofit because you are soliciting donations and you want to I as a consumer want to make sure that my money is going to the organization that I intend to support.
Okay, so what do we do when we are talking about trademark clearance? So the initial thing that we'll do is we do what we call a knockout search, and it's free of charge for pro bono clients. And what we do as your legal representatives, we will search the United States Patent and Trademark Office, which is the federal organization that registers trademarks. We will look into some international registries if that's pertinent to your organization. And we also do just a general search engine search. That's literally just searching the web to see what kind of common law uses might be out there. We'll also look at domain names to see what's available for you should you decide to use any of those. And we can also look at state registries like the Secretary of State's website to look at similar business names that may not have registered their trademark with the USPTO and may not have a website out there that would come up in a search engine search, but will be registered with the Secretary of State, so you'll know that there's someone else operating somewhere out there with maybe the same name that you're looking at. Further to that, if your mark is maybe available or if it is available and you just want more peace of mind, we can do full clearance searches. These do run, upwards of $1,000, depending on, the breadth of the search performed. But that is because, it's not our fees, but it is because of databases that we subscribe to and that charge these sort of fees back. So this will include, of course, the USPTO, but it also includes a really broad search of international trademark registries, and it's a more extensive common law search. And these are databases that we don't have access to in-house, but the companies that we subscribe to are able to, dive deeper into other databases that can provide more information to them about what's out there. And then also, if you're an international organization, you may want to consider, specific, deeper international searches, and those costs just vary by country.
That brings up a point that we didn't include in our slides, but trademark rights are territorial. So if you own a trademark in the United States, that does not mean that you own the same rights in Mexico, Canada, or in Europe. You would have to secure protection for that mark in each territory. Conversely, there's something called the Berne Convention that allows you to extend your copyright protection in the U.S. to other countries that are members of the Berne Convention. So it is not as restricted by territory as trademarks are.
Yeah, that's a great point. Okay, so what do you do if we've done a clearance search and the mark that you love is not available? I mean, the first and easiest thing to do would be to select something alternate. But you could also maybe think about a variation of that mark and modify it in some way that is different enough in a legal assessment that we feel would be more unique and more registerable. If you decide that you really love the mark and you just want a little bit more information about the other party that is using something that you're interested in, we can do investigations. We can try to get more information about, well, are they actually operating a business? Or maybe they just, they registered this mark, but they're not using it anymore. There's always information that we can get for you to then assess, the next steps. Those next steps may be a coexistence agreement, and that means reaching out to that party and trying to find a way where you can both operate in the marketplace together, but maybe your services are in a small way different, or you will agree not to do this one aspect that they operate in. So there's different ways we can come to an agreement where you could both coexist, or we could try to buy them out. And that would just be acquiring their marks. Maybe they just don't care, they don't want to use it. But those are all options that you can pursue if we do find out in the clearance portion of the trademark search that your mark, the one you decided on, is not available. If it is available, the next step that we would always suggest is filing for registration of your mark. And while, trademark rights are use-based and you do get rights just based on your use, it's always, just like it is for copyright, it's always recommended that you try to pursue a registration certificate with the USPTO. So there's two types there's more than just two types. But here we've listed two types of registrations, and you can register your word mark or your logo, or you could register both as a composite mark. Each one of these would be a separate application. You can file your mark as intent to use. So maybe you guys are in the initial stages, the planning stages of your organization, and you're not yet in the marketplace. It's still a good idea to go ahead and file an intent to use registration, and that kind of secures your place in line with the registry. When you file as intent to use, you have about up to 3 years to actually use your mark in interstate commerce. You would file for extensions every 6 months, and of course there's fees associated with this, so it is the more expensive option than filing a use space, but it is an option if you want to go ahead and secure that place in line. If you are actually using the mark, then of course you want to file a use space application, but please note that you must be using your brand in interstate commerce. You can't just be, confined to only the greater Atlanta area. So this would include, maybe mailing out brochures to clients around the U.S., having a website which is accessible by people all over that maybe they can purchase products from. Anything like that creates an interstate commerce, then you can file use-based application.
Yeah, and just to be clear, just having a website alone is not enough to
Right.
demonstrate interstate commerce. You have to actually be conducting commerce via that website. So offering your services via the website to citizens outside or residents outside of Georgia.
When filing the trademark, just so that you know, the USPTO divides goods and services into 45 classifications, and they call this is the NICE classification system. What we've listed here is just a few examples of classifications that might be pertinent to pro bono clients. I think the most frequently used in my experience is probably class 45 or class 35, and that's going to protect, your basic business services. And once you do that, you might then also think about all the other things that you do that fall into any of these other classes, like particularly education, if you do any seminars or webinars, things like that, retreats. Those are all things to consider. Of course, each of those is a separate fee. Every class that you try to register your mark in is going to be the $325 filing fee. So. And I won't go into detail on this slide. This is not so simply the trademark application process. I mean, this is why we have jobs. It is a little bit difficult to navigate, and that's why we encourage, and we have the wonderful organization of Pro Bono Partnership that pairs us up so that we can help you navigate this field and, guide you through every step of the process, do most of it for you, but help you along the way as your mark registers or moves on to register, anything that might come up in that process.
That's a good point. You can file for an application yourself. You don't need an attorney. You just file as the owner of the trademark, but it is a rather complex process, as Carly's laid out here. So it's probably advisable to have an attorney or a competent paralegal like Carly help you out.
Okay, so I did mention previously cost just a little bit, but this is basically giving you some examples of the cost. So filing fees, and this is for use space or intent to use, it's $325 right now per class. The additional fees come is if you file intent to use, like I mentioned, every 6 months. If you file an extension, it's another $150 every time. You might incur attorney fees if you choose to, go outside of pro bono. It's generally free for pro bono clients. Should you run into any oppositions, you have costs associated with those. And additional fees for intent to use applications come where you do finally use your trademark and you filing proof of use applications. We call those statements of use. And once your mark registers, you have renewal fees. So every 10 years or so, you'll have to renew your trademark registration and prove that you are still using your trademark in interstate commerce. So these are some of the fees that you might incur in trademark registration. Some other costs to consider are domain names. Should you decide to register, your place in the internet marketplace, you'll want to secure a domain name. And while those are generally relatively cheap, you could purchase one on GoDaddy for about $20 a year, maybe. It just depends on how many you purchase. And there's also different you have different global top-level domains is what they're called. Right now the common ones are .com, .net, .org, but soon we will be introduced to hundreds of new ones, and one of those is actually .charity. So it's not available now, but it's something to think about that's coming soon into the marketplace, that if maybe the .com name that you love so much is not available, you could snag up the .charity name, the exact same name, but have the .charity extension. Also, if your organization extends into other countries, and you might want to consider there's country code extensions too. If you want to create a website that's specific to Mexico or Canada or anything like that, those are also available options, but cost generally a little bit more than if you were to secure, a .com or a .net or .org. So those are other fees to consider when you are registering your brand and your trademark.
Thanks. Mm-hmm. So Carly's taught you about how you go about selecting a brand, how we search and clear those brands, and then ultimately how we prosecute, how we secure trademark registration for those brands, as well as some ancillary costs like domain names for that. I'm going to talk to you about how you use your brand. What should you do? We've probably all seen the little circle R designation or the TM or even the SM designation, and You may know, but I certainly didn't before I started practicing trademark law, what those meant and what they stand for. So the circle R means you have a registered trademark, not just the application. This is after we've prosecuted it successfully and you have a registration certificate in your hot little hands and you can stamp a big circle R on your trademark. Now remember, your trademark rights are territorial, so if you don't have registered rights in Mexico, but you do have them in the United States, then be sure that you're only distributing the materials that you have in the United States. I recognize that websites are accessible from all over the world. You might want to take the position that you are targeting the local area of Atlanta, and therefore you could put a Circle R designation on your trademark. A TM designation is an unregistered trademark. So if you've just filed your application but you haven't gotten the registration certificate, you'll see a little TM there. Or an SM is like a subset of the trademark, the TM designation, and it's just for services. And in most cases with the nonprofits, you are providing services, so you could use the SM designation if you prefer. But frankly, I just usually use the TM regardless. Mm-hmm. You'll put that designation usually on the lower right-hand corner of your mark. You don't want it to actually touch the mark. You want to have just a little bit of white space next to it. And then you only need to put it on the first and or most prominent use of the mark on the materials. So you don't have to put a Circle R every time you mention your company name in a newsletter. Just maybe if it's on the header, then you'll want to put it there. Then you need to put a legal line at the bottom, and I'm going to talk to you in a minute about what that legal line will say, but it refers back, just like a footnote, it refers back to that Circle R or that TM or SM. You want to have consistent use of your logo, and this is kind of an issue in the trademark world right now. I think you're probably familiar with Google, and they change their logo almost every day. But that means that they've sacrificed some of the rights that they might have in the presentation of their logo. If you're consistent in the use of your logo, if we work at Turner Broadcasting, CNN is one of our networks, it is always in red. So if there is another organization, another news organization that starts to use their mark in the color red, maybe that alone is not enough for us to claim infringement. But if they connect the letters like CNN and it's in red, then I think we have a much stronger argument. If CNN showed up in 15 different colors all the time, then that would weaken our argument. So it's important that you try to keep consistent use of your mark as much as possible. When referring to your mark, when referring to it as a trademark in editorial content, you want to distinguish the marks from the surrounding text. You can do that in a variety of ways. You can put it in all caps, you can put it in italics, you can put quotation marks around it, you can underline it. Certainly using the TM or Circle R designation next to it will help to do that. But you just want to make clear that you are referring to a brand and not a generic product. So if your organization is called Feed the Sick, then you want to make sure to brand it as Feed the Sick so that it's not suggested as some sort of generic term for your organization. And we've listed here some examples of how you might go about doing that. You always want to use your trademarks properly and in their entirety. We have here the example of Harley-Davidson motorcycles, not Harleys. If your organization often goes by an acronym, that's fine to use the acronym if it's separately, it's considered a separate mark, but you don't want to abbreviate it. If it's, what was yours earlier, Carly? The World Teaching Foundation. Of course, we probably don't want to use WTF as our acronym, but if you started abbreviating it to World Teachers, then you would lose the strength of your rights in the underlying mark, World Teaching Foundation. You don't want to make a trademark possessive or modify a trademark from its possessive form. So if it's the Food Network, not the Food Network show, it should be the show on the Food Network. That's a very technical thing, but a pet peeve of ours, so try not to do it. And you shouldn't use a trademark as a noun. You should refer to it, particularly in promotional materials and things that have very prominent use. We refer CNN obviously as CNN, and in some cases that's considered a noun, like this is CNN. I'm sure I sound just like James Earl Jones,
Yeah,
too.
exactly.
Mm-hmm. A lot of people confuse us. But you want to try to refer to it as the CNN television network, or in this case, Maggiano's restaurant, to again make clear that this is a brand that is meant to brand the good or service that's associated with it. You never modify a trademark to the plural form. Instead, change the generic word from the singular to the plural. The registration here, the example here is it's Tic Tac Mints, not Tic Tacs. So certainly we all refer to them as Tic Tacs. Mm-hmm. Just like my mom always calls it Kroger's rather than Kroger. But we want to say Tic Tac Mints. If you are the brand owner, you want to be sure you're using your brand properly and consistently. And then finally, don't use your trademark as a verb. If you do, you're running the risk of making it generic. I know my fine colleagues at Xerox are very careful to say photocopying, not Xeroxing. Our good friends, we have a former colleague who's now at Google, and he would certainly say conduct a search, not Google the term. So you want to be sure to do that to avoid any implication that might become a generic term and you'd lose your trademark rights. And then finally, what's the importance of that? Well, I'm asking you to do all these little technical rules. Well, A, it protects the strength of our brands, which equals exclusivity and value. If you are feed the children, then you want to be sure it's always clear that it's feed the children, not feed the kids, not feed the children's, I don't know. Because that protects the distinctiveness of the mark and it increases the value and goodwill associated with the mark. Also, if you don't properly use it, you could run the risk of becoming generic. As I mentioned, our friends at Xerox and Google probably worry about that to some degree. We've listed here a few terms like escalator was once a brand name, but it has now become a generic term for moving stairways. And then finally, I promised you that we would talk about legal lines. Remember, I told you about the Circle R, the TM, or the SM designation. And the bottom right-hand corner is the preferred place. It doesn't have to be. It can be elsewhere close to the mark. And then at the bottom, this is particularly on your website or on your newsletters, I would love to see a legal line that puts the world on notice that I am the owner of this intellectual property and I'm the one claiming rights. That's going to look something like Circle C for the copyright, and a Circle R or a TM designation, depending on which one you put next to your logo at the top. The year of publication, the name of the entity that claims ownership rights in the trademark copyright, and then I like the words all rights reserved. Not everybody requires that, but we like it. And so it would read something like, if your organization is World Teaching Foundation, TM and Circle C 2014 World Teaching Foundation Inc. all rights reserved. And that's how you would properly use your mark. So we've walked you through trademarks and copyrights. I know we've thrown a lot of information at you. If you'd like to rewatch the video, particularly the first part where Carly had those completely unsolicited and kind words to say about me, then you're welcome to do that. And certainly if you would like to contact Pro Bono Partnership of Atlanta, please do. Thanks.